All right, good afternoon, everyone. My name is Kathy Purdy. I'm a marketing manager here at Schoeneck King. I'd like to welcome you to this week's coronavirus webinar presentation. Two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows. Once the program has ended, if you would take a moment to complete the brief survey, we would appreciate that. Our presenters and attorneys do look at your suggestions for future topics. So if you could just take a moment to complete that, we'd appreciate it. So to kick today's program off, I'm going to hand it over to Pete Jones.
Thank you, Kathy, and good afternoon, everyone. It's good to be with you again. It's a snowy day here in Syracuse. I understand it's making its way up the thruway. Hasn't made it to Albany yet, but is expected. But we're getting hit pretty good here. So we're going to start off today with Teresa Rusnick. She's in our Rochester office. Teresa is going to walk us through the most recent Department of Labor guidance on New York State's COVID paid leave statute. Teresa, please take it away.
All right, thanks, Pete, and good afternoon, everyone. As Pete said, we are definitely getting some snow today, but that is not my topic. I'm going to be talking about some recent guidance on the New York COVID-19 leave law. And I'm just going to start by taking questions in the past couple of days, pretty much ever since this guidance came out last week, that have I think, spoken to the need to just remind everyone of what this leave law is all about. So as a refresher, back in March 18th, 2020, New York State passed a COVID-19 leave law. This applies to all employers, private and public, of every size, and we'll see in the next slide that different leave amounts apply to different size employers and is somewhat dependent on income level as well. But it basically applies to every employer in one way or another. It did not expire at the end of 2020, unlike the FFCRA, the Families First Coronavirus Response Act. The federal legislation, which I know got a lot of publicity because it did expire, this law, the New York COVID-19 law, did not expire at the end of 2020. And another thing I think is important to point out here is that this is not New York paid sick leave. It is paid leave, usually when you're sick, and it is in New York, but it is not New York paid sick leave. So I just want to try to make that as clear as possible up front. This was enacted in March. It is directly tied to the pandemic. New York paid sick leave, the one that you've all heard me on these webinars talking about ad nauseum, the one that was effective January 1. It provides leave in all sorts of paid leave circumstances, in all sorts of sick circumstances, not just COVID-19 ones. So I think it's important to give the distinction between those two. Can I have the next slide, please, Kathy? So this is the New York COVID-19 leave law in a chart, or at least as much as I could get it in a chart. So this, as you can see in the first column, is based on the number of employees as of January 1, 2020. I think they picked that date because this law was enacted in March of 2020. And as you can see, the amount of leave and whether or not an employee gets supplemental benefits are all tied to the number of employees that an employer has, and to a certain extent by income as well. So if you have 0 to 10 employees and a net income of $1 million or less in the prior tax year, the employee is entitled to unpaid leave for the duration of the order and is eligible for combined paid family leave benefits and disability leave benefits for the duration of the quarantine order. And as a reminder, at least when we're talking about the traditional New York COVID-19 leave law, that is leave that's connected to an order of quarantine. That order of quarantine is typically from the state or from a health department, and that is what triggers the leave, at least as it is set forth by this chart. And kind of put a pin in that because we're going to talk about the new guidance and how that disrupts this scheme. But all of this is triggered by an order of quarantine and is somewhat governed by the length of the duration of the order. So when you see order referenced on this chart, that's what I'm talking about there. So 0 to 10 employees, net income of $1 million or less in the prior tax year, you're going to get unpaid leave for the duration of the order of quarantine. Those are usually 10 days to 2 weeks. And for that period of time, the employee may be eligible for a combined paid family leave and supplemental disability benefit. If you have 0 to 10 employees and a net income of more than $1 million in the prior tax year, you get 5 days of paid leave for your employees. That is paid at the employer's expense. There is no tax credit for that, the way we saw under the federal law. So that is at the employer's expense. And like I said, it's in addition to New York paid sick leave. So the employer would receive 5 days of paid sick leave to cover the beginning of the order of quarantine. And then for the duration of the order of quarantine, they would be entitled to a combination of paid family leave and disability benefits. If you have 11 to 99 employees, it looks very similar. Regardless of your level of income or net income of the employer, if you have 11 to 99 employees, your employees are entitled to 5 days of paid sick leave pursuant to an order of quarantine. And then after those 5 days have been exhausted, a combination of paid family leave and disability leave for the duration of the order. For those with over 100 employees, as well as public employers, your employees are entitled to 14 days of paid sick leave, which generally will cover the entire duration of the quarantine order. If you're one of those that falls in the category of paid family leave and disability and you're looking for those forms, both of those are available through New York State's websites. And I will put them in the chat as well when I finish this presentation, just so you all can access them. Next slide, please, Kathy. So that is the New York COVID-19 law as we knew it for many months, as we basically knew it from the middle of March to January 20th, 2021. It was directly tied to the order of quarantine. It was limited in that way, some might say. But then last week on January 20th, the New York Department of Labor published guidance regarding the New York COVID-19 law, the one that we've just been talking about. I posted the link where the guidance is available, so you can all access it there. It's also available through the Department of Labor's website if you search around on that. The guidance expands the obligations of employers regarding the New York COVID-19 leave, and it does that in several critical ways that we're going to be talking about. Before I get to that, you'll see that I have statutory authority with a question mark underneath the guidance expansion bullet point. That is because the expansion of the New York COVID-19 leave does not appear to have as much support or really any support in the statute for New York COVID-19 leave that we would typically see when the Department of Labor expands upon a statute. So, there have been some general questions raised about whether or not this guidance would pass legal muster in a court or otherwise, but for now, it is effective guidance from the Department of Labor, and we should treat it as such. So next slide, please, Kathy. So the new guidance starts by saying that if an employee tests positive for COVID-19 following a period of mandatory quarantine or isolation, the employee cannot report to work, is automatically deemed subject to a subsequent mandatory order of isolation from the Department of Health, and is entitled to paid sick leave under the New York COVID-19 sick leave law. This is even if the employee has already received New York COVID-19 sick leave for the first period of mandatory quarantine or isolation. And in order to receive that leave for the second time, the employee has to have had a positive test and submit verification of that positive test to the employer or to the insurance company if you're looking at a combined paid family leave, disability leave situation. So to recap, if someone has already had a mandatory quarantine or isolation period, they've already gotten that order from the Department of Health, but they test positive for COVID-19, they can't report to work. They're automatically, per this guidance, deemed subject to another order, even if they don't necessarily have the order paperwork the way they did for the order of quarantine the first time. And they're entitled to paid sick leave under the New York COVID-19 law, which means they're either going to get the 5 days or the 14 days in the case of the vast majority of employers. And in order for them to get that, remember, the second time they have to test positive for COVID-19. All right, next slide, please, Kathy. So, and this is a similar situation, just varied slightly. So this is if an employee is subject to an order of quarantine or isolation and continues to test positive at the end of the quarantine or isolation period. So someone's been out for 10 to 14 days, they get another test, they're still positive. In that case, they can't return to work. They're automatically deemed subject to an additional period of quarantine from the Department of Health. They're entitled to an additional 5 or 14 days of paid leave under the New York COVID-19 leave law. That's even though they've already received their first period of quarantine. And in order to receive the quarantine leave for the second time, they have to submit verification of the positive test. Next slide, please, Kathy. So the guidance also says that an employee cannot use the New York COVID-19 leave more than 3 times. So if someone goes out once, subject to an order of quarantine, they get their 5 days, their 14 days and supplemental benefits. They test positive at the end of that period of time, they're deemed subject to another order. And then if they test positive again, they're deemed subject to a third order, and they can get paid for, the 5 or 14 days each of those times. And those times may run concurrently with one another, which I think is what makes this a little bit tricky, or one of the things that makes this a little bit tricky. But the key here is that an employee cannot use the New York COVID-19 leave law more than 3 times. The guidance does put a cap on the total use of New York COVID-19 leave at 3. Now that may be a small consolation for some employers, given what I've just told you, but at least it is capped at some point and doesn't go on in perpetuity. We'll save that for the next slide. The second and third uses of the leave, as I've stated, must be based on a verified positive test. It can't just be like a precautionary order of quarantine, or someone saying, I was exposed to COVID and I have an order of quarantine, so I'm entitled to New York, or, I was exposed, I don't have an order, I'm not positive, but I want another 14 days of leave. That's not going to work for this part of the guidance. I will note, and if you've read the guidance, it's not recommended, and it says so right there, that an employee who has been quarantined pursuant to a governmental order receive another COVID-19 test before returning to work. I have an exception there for nursing home staff per the guidance, but it's not necessarily recommended that you require your employees to get tested before returning to work if they've had COVID-19 or if they've been subject to a governmental order of quarantine. If the Department of Health says that they can come back to work, then they can come back to work. Should they happen to receive another test and continue to test positive, as I think will be the case for many people, as we know that people can continue to test positive long after they're really deemed contagious. Per the new guidance, they have to continue to stay out of work, and they are deemed subject to that second period of quarantine and get the leave. All right, next slide, please, Pete. Okay, so this, believe it or not, is the trickiest part of the guidance. So what I've just said added quite a bit, but this I think goes a step further, and I see Pete smiling, so I know he agrees with me. So the guidance, in addition to everything I just said, the guidance also appears to require employers to provide employees with paid leave, not necessarily COVID-19 leave, and not necessarily New York State paid sick leave, if the employee is not permitted to come to work because of an exposure or potential exposure to COVID-19, regardless of whether there is an actual order of quarantine in place and regardless of whether the employee has actually tested positive for COVID-19. So this is quite broad, and speaking of exposure, it's regardless of whether such exposure occurred in the workplace itself. So until the employer permits the employee to return following the exposure or potential exposure, the employee gets paid for the time that they're out of work and not able to work. It's unclear for how long that could potentially go on for. It's unclear how many times that could happen. The guidance says the pay continues until the person can either 1, come back to work, or 2, is subject to a mandatory or precautionary order of quarantine from the Department of Health or the state, at which point they would receive either their 5 or 14 days of paid leave, and then depending on the size of the employer, the supplemental benefits. So I know this is a lot. It certainly was quite a Wednesday afternoon for us in the Labor Department over at Bond. I've certainly seen a lot of questions come in about this, probably particularly about this last point. So please feel free to reach out to us if you have additional questions about this. We're happy to talk to you at any time. I know I'm not going to be able to get to everyone's questions today, but I or any of my colleagues are always very happy to talk about this, and please feel free to contact us. Pete, I'm going to turn this over to you.
Thanks, Teresa. Before we leave that, and I do want to summarize this, so we'll take a look at this next slide in just a second. But I can always tell when we've struck a nerve because the Q&A box lights up faster than you can even read the questions, and we struck a nerve. I can report that. This reminds me of early days. We've been doing this for 10 months.
We didn't strike a nerve. The Department of Labor struck a nerve.
Fair point.
Don't make the news. We just report it. Okay, let's make that clear.
Yes, agreed. But it's clear that this is a question, an issue that people have lots of questions about, and I'm going to go harken back to my standing advice, which is I think you're going to need to reach out to your bond attorney on this one. It's complicated, and although this is guidance that arguably makes it clearer, in many ways it muddies it. But there are 3 interesting things that Teresa reported on that I just wanted to emphasize. One is there are these provisions in this guidance, and it's not a regulation, it's guidance, that talk about a deemed an order of quarantine. That is not a concept that we see in the statute, but it's one that we see in the guidance. And so when you see that, you have to ask yourself, is that an interpretation of the statute, or is that something that goes beyond what's in the statutory language? Secondarily, there's a reference, as Teresa mentioned, to 3 periods of quarantine. That is also not something that appears in the statute. People have wondered whether it's 1 period or more than 1. And 3 is a number that has been selected and made clear in this guidance as DOL's position. But again, we have to take it for what it is. It's guidance. And then the last thing, and perhaps the most controversial thing of all, is this provision that says if the employer holds somebody out pending the order of quarantine, that the employer would have the obligation to pay during that period of time. Again, that is not in the statute, and so that goes beyond what's in the 4 corners of the document. So we'll have to see how this goes, whether there will be challenges. We'll have to see whether there'll be additional guidance or perhaps regulations. But as Teresa had reported, for now, this is DOL's statement of their position on what the statutory language would mean. Okay. Given that, I wanted to take just a minute. I think this is remarkable. There's much about the pandemic that is remarkable. The world has changed in so many ways. But if you think about this period, this is about a 10-month period. Since April of 2020, we've had these 3 statutory developments, and they have a huge impact on my 4th bullet here. First, you had your FFCRA. Of course, that did not apply to anybody. It was a question of employer size. That statute expired. You do have the option to continue providing those benefits and getting a tax credit, at least up until March 31, under the most recent relief legislation. And there's a possibility that this could be extended, reenacted, possibly even retroactively. It's something that is on certainly on the radar, has been indicated by the Biden administration, so we'll have to see. But for right now, this statute is expired, and you have the option to continue that kind of leave and get a tax credit under guidance that has not yet been issued by the IRS, so we'll have to see what that says. At the same time, we've got this COVID leave statute that Teresa has just walked us through. It is triggered by an order of quarantine. That is for certain. That's what the statute says. But we have these new questions about how many times it could be used, whether someone might be eligible for leave without an order, this notion of a deemed order, or the employer holding somebody out. And so there's still a lot of unanswered questions here. And we can see obviously in our chat that it's on your minds. You've posed a number of permutations. And then finally, and Teresa had alluded to this as well, independent of the COVID leave, effective January 1 of 2021, the New York State paid sick leave provisions went into effect, not applicable to public employers, but broadly applicable to the rest of the employers, and it has to work in concert with, but independent of, these other forms of leave. As if that weren't enough to keep on your radar, for those of you who are in a collectively bargained environment, you're going to have to figure out how this meshes with your collective bargaining agreement, and to the extent it does or doesn't, whether there are impact bargaining issues. So there's an awful lot to keep track of here. I think that's why we're seeing so many questions in the chat. But frankly, they're so fact specific that I think you're going to have to work through these things on a case-by-case basis and with your labor attorneys, because there is no one size fits all on this. Okay, want to shift gears now. Hopefully that was a helpful start on this topic. I don't think it'll be the last word on this topic. We're going to go now to Craig Anderson. Craig is in our Albany office, and these are some recurring questions that we've had. You know, what do we do with the medical information? How does HIPAA play into this? And Craig's got some thoughts. He's going to walk us through it to give you the basics and then build on those principles.
Thank you, Pete, and good afternoon, everyone. It's nice to be here talking about a topic that has been raised in so many new contexts during the last many months of the public health emergency. So as testing and vaccine, as those processes continue, one question that we are frequently asked is how HIPAA applies in the context of sample collection, testing, reporting, vaccinations, and just and many of those related contexts. So as many of you know, HIPAA refers to the Health Insurance Portability and Accountability Act. It's been in place with us since 1996 and has been updated over the years to provide for various protections. Healthcare providers, insurers, and to some extent employers have been navigating HIPAA for years. But with the new way of life that we find ourselves in, obviously new questions are arising. And they're often, typically we've dealt with HIPAA so frequently in the healthcare context, and now we're seeing some recurring questions, as Pete said, arise on kind of a daily basis outside of that typical setting. So I wanted to address just a couple of general background questions that we've been asked over the past few months, and try to narrow down some of the main focus of when HIPAA applies and why, and when it may be a consideration for you. So the first question I've posed here is HIPAA being enforced during the public health emergency? That's frequently being asked, and the answer is absolutely yes, it is. You may hear comments that the Office for Civil Rights, or OCR, they're the office that has been charged with enforcing HIPAA. You may have heard comments that they've decided to exercise discretion in enforcing certain provisions, and that is true. However, it doesn't mean that HIPAA is not being enforced. Although much of the information can be shared on the basis of the existence of the public health emergency, or the fact that disclosures are made to public health authorities as opposed to other entities, OCR is still very much enforcing, through penalties, HIPAA violations. Additionally, the initial focus of the enforcement discretion really was geared towards applications of telehealth. The OCR had explained that covered healthcare providers would not be subject to penalties for violations of HIPAA when they occurred in the good faith provision of telehealth during the COVID-19 public health emergency. So there is that sort of blanket enforcement discretion going on. In fact, just last week, they've sort of updated that to apply to certain web-based scheduling applications that are used for reporting and vaccination scheduling. But generally, HIPAA is still in place and it is still being enforced. So now that we understand that HIPAA is still a concern, the next big question is, does HIPAA apply to me and or my organization? And I think it's important to keep in mind that the definition and the scope of HIPAA hasn't really changed during the pandemic. So HIPAA still applies only to covered entities and business associates. By way of a brief background, I guess I should note that a covered entity typically includes healthcare providers if they transmit certain information electronically. And remember that when we're talking about HIPAA, we're only dealing with protected health information. And typically that is information that's being transmitted electronically for certain purposes. So a covered entity is usually a healthcare provider, health plan, or a healthcare clearinghouse. And a business associate under HIPAA is an entity that is engaged by such a covered entity to assist in carrying out certain healthcare functions or activities, where there is also an exchange of, again, protected health information. That's key. That needs to be part of it. So a full analysis as to whether your organization or which parts of your organization need to be concerned about HIPAA does, in fact, depend on what services you're providing, what business you are operating, etc. But in short, HIPAA should only apply to you and or your organization to the same extent as it did before the pandemic. It may be that the only individuals in your organization, for example, that are concerned with HIPAA are HR professionals that are interacting with with your organization's health plan. That may be the limit to it. For others that are providing more extensive healthcare or related services, then that's obviously going to be a bigger concern. But the fact that your organization has or receives health information or medical information does not, in and of itself, make you a covered entity or a business associate. And that really is where a lot of our questions have come from, is that sort of concern of, we have this information that's being provided to us, or we're being asked to provide this information that we've received. And to the extent that you have that, it doesn't necessarily make you covered by HIPAA. Now, it may be, and this is, again, very important to know, that information is covered by other state or federal laws. I want to make that clear, that just because HIPAA doesn't apply or is limited in its application, it doesn't mean that your organization won't have other duties or obligations to protect health or medical information. For instance, the requirements of the ADA and FMLA still apply to that information. So I think with that in mind, the last question I want to discuss, and this is a bit of a newer one. It's really arisen in just the last couple of months of the public health emergency, as we're really sort of stepping up the vaccination process and the reporting process to a greater degree. This question is, do I need a business associate agreement to provide information about those involved with my organization? For example, do I need to be a business associate agreement to provide information about students, employees, or others to a lab for purposes of testing? Unfortunately, this answer isn't completely definite, or maybe I should say it's not definitively answered just based on that question. It is a very fact-based question, but the answer to that is maybe not. You may not need a business associate agreement, and I'll describe a little bit about, for those of you who may not be familiar with what a business associate agreement is. It's frequently called a BAA, and it's an agreement that is entered into by the covered entity. Remember, that's usually the healthcare facility or health plan, and their business associate who's providing those supporting services to the covered entity. So a business associate agreement is required in situations where there's an exchange of protected health information of individuals between the covered entity and the business associate. We have seen this issue arise frequently from this question has arisen frequently from entities that are not typically in healthcare, but who are required to conduct testing. This would include schools and general businesses that are required to conduct that testing. And in recent months, we've had a number of testing companies, labs, and even local health departments try to force organizations to sign business associate agreements in order to share information. And I'm not saying, I know I use the word force and it has kind of that negative connotation to it. I'm not saying that a business associate agreement isn't always appropriate or necessary, but I think there needs to be an analysis done by you and your organization prior to just sort of blanket signing that document. It's important to fully realize whether you are truly covered by HIPAA, and certainly OCR, again, the agency that's been charged with enforcing the HIPAA regulations. It's key to them. One of the big concerns to them is, does an organization understand its role under HIPAA? And if you're signing a business associate agreement when you're not truly a business associate rather, there I think are some red flags and some concerns. So my comment and my advice, I guess, is that just please keep in mind that the fact that your organization receives health information or medical records does not necessarily by itself make you covered by HIPAA. And there still may be times when you need to enter into a business associate agreement, but be sure to coordinate with legal counsel as appropriate to determine whether that's really truly a need. And with that, I will turn it back over the time to Pete.
Thanks, Craig. Very, recurrent question there. Do we have to enter a business associate agreement? I think the other thing that you said, and I want to make sure we emphasize this, is that you likely have some obligation to maintain medical information confidentially, even if you're not covered by HIPAA. I think you alluded to FERPA, or at least schools and colleges and their obligations under the FERPA legislation. And for employers, we certainly have obligations to maintain medical information confidentially. So there's likely, the instinct I think is correct, that this medical information needs to be maintained confidentially and carefully. There's some statute that applies, but it's been commonplace for people to call it HIPAA, probably because every time they go to their provider, they need to execute a new HIPAA set of documents. But technically, in most cases, it probably will not be HIPAA covered.
Absolutely.
Okay, let's turn this over to Katie Anderson. Katie's also in Albany and is going to give us the latest from Albany.
All right, the latest and greatest. Yes, the latest and greatest is that it is not snowing yet, but it will be soon. First up, looking at this case count that's happening in New York. Last week, I said to you, the cases are going down. We are going to see a rise in hospitalizations and deaths. That is correct, and that is still the case. Cases are going down in New York. And the good news on that front is that the governor announced yesterday that they are re-examining the microclusters because the holiday surge appears to be over. We are guessing that tomorrow, the governor is going to potentially be making an announcement about removing microcluster designations, or at least moving communities from orange zones to yellow zones, or removing yellow zones, since they really haven't been touched since that week before Thanksgiving. So that is good news. I know people have been anxiously trying to figure that out, when that will end. If you look, Katie, also, yeah.
Do you think, does that mean that they may go with a different strategy, or they're just going to revisit the designations within the existing strategy?
That's what I was just about to touch on, because when you look at what happened yesterday in California, California's governor fully removed the stay-at-home order that has been issued for California, but the other restrictions remain in place. But it's very unclear what's going to happen. Will certain restrictions still be around? Will it still be, the baseline restrictions are still there for those of us who are not in cluster areas, right? So in Albany, I could go to a restaurant if I wanted to and eat indoors at a 50% capacity. That will still be the case, but it's really unclear if we're going to be using this. It seems like we're going to be walking away from this microcluster strategy and that there won't be new ones to take their place. That's my educated guess based on what the governor said yesterday, but we'll see how it goes. Hopefully that answered your question. I do have other good news though, too. The vaccines have been working well against the new variants. Last week, I spoke to you about the threat that these new variants present, one of them being, will it render the vaccines ineffective? Yesterday, Moderna came out saying that it's just as effective. Their vaccine is just as effective against the UK and the South African variants of the disease, which are more contagious to the point that if you do not have an N95 mask, the science is now recommending that you wear 2 masks at a time. So now when I go grocery shopping, I am wearing 2 masks because they are so contagious that 2 masks are really needed. That's just a tidbit I thought everybody would be interested in knowing. This is a question we've been receiving a lot. And so I thought it was worthwhile to at least touch on this. What impact does the vaccine have on travel advisory quarantines or quarantining because you have been exposed to COVID? The answer is no impact. New York has not updated its guidance. There is no impact. It does not matter if you receive the vaccine, you travel to Florida, and you come back. You still have to follow the travel guidance that exists. Same thing with if you are exposed to COVID-19. If you have the vaccine at this point, you still have to follow that guidance. That's what the Department of Health is saying. The reason for that, I wanted to include that because, at first blush, it doesn't make sense. But when you dig into it on a larger scale, it does make sense. People who have received the vaccine may, 1, still spread the disease, and 2, there is a chance the vaccine won't work in everybody. It's 95% effective. But when you're doing that, when you're putting that on a large scale basis, that means that if 1 million people receive the vaccine, 50,000 may still get COVID-19. And until we reach this herd immunity point, there's a good chance that the vaccine, it's not going to make that big of a difference in the guidance documents coming out from New York State. So hopefully that is helpful. I've been very interested in this. And, I think going forward, maybe we'll see updated guidance, but I'm not confident in that. Turning to another paid leave fun issue. I don't want to steal Teresa's thunder, and I never could. But in the budget, there is legislation that was introduced last week that would implement paid leave for when an employee receives the COVID-19 vaccine. It would be upon oral or written request from the employee. That employer would have to provide up to 4 hours of leave. Those 4 hours would be used for the 2 COVID vaccines that the employee would receive. The employers that do arrange or provide for the vaccine at the workplace would only need to provide sufficient paid leave for the employee to receive the vaccine. So however long it would take for them to receive it and then sit in that waiting room afterwards. Employers cannot take retaliatory actions against employees who need to use this leave, who request to go get a vaccine. And employers may ask for documentation from the employee confirming that the employee's eligibility to take the leave under the act. So basically confirming that that employee would be able to, go get the vaccine, that employee falls into a category that would receive the vaccine. Now, remember, this has not passed. This is just legislation. At the earliest, if this remains in the budget, this would pass by April 1st, likely. So I know I've been speaking to you over the past few weeks about when the vaccine is going to be more widely available. The reason I wanted to include this is that this will likely be implemented at the time when many of you are going to be trying to get your essential employees vaccinated. Keep that in mind, because this is something else that you will likely have to contend with. And we will give, obviously, more updates in the future as it comes about this legislation and if it's actually implemented. And finally, just really briefly, Executive Order 202.91 was issued over the weekend. This tells different entities how to prioritize the vaccination. So local health departments and county governments are to prioritize essential workers in Category 1B. Hospitals, they are to prioritize healthcare workers. Pharmacies prioritize individuals that are over the age of 65. And importantly, this executive order says that providers should not be scheduling appointments until they receive allocations. The problem in New York City last week, you had to have appointments that were canceled or rescheduled because New York City ran out of vaccines. Expect that this will, it's a should, it's not a must. And so I think we're going to see some flexibility here, but this was really, that part was issued as a direct response to running out of the vaccine in New York City. With that, I am done.
Thank you, Katie. It's good update on a range of issues. We're going to turn now to Laura Harshbarger. Laura is going to talk to us a little bit about what's going on at the New York State Division of Human Rights, and in particular, some of the coronavirus angles that are kind of influencing the activity there.
Thanks, Pete. So the New York State Division of Human Rights is our state agency that enforces and investigates complaints made pursuant to the New York State human rights law. Now, the New York State human rights law prohibits discrimination on various bases. They're the things that we typically think of as our protected characteristics: our race, color, religion, age, disability, national origin, gender, sexual orientation, transgender status, pregnancy, those kinds of factors. And the New York Human Rights Law, as I said, prohibits discrimination on those bases and harassment on those bases. The usual process that the Division of Human Rights follows for processing a complaint would be that the individual with the complaint presents their complaint to the Division of Human Rights in writing with a complaint form. Normally, obviously, the Division of Rights is open for business and people can walk in and file these things. Currently, the division is all online, and that's really not kind of any kind of major noteworthy change. After, in the normal situation, after a person files the complaint with the State Division of Human Rights, the division will forward the complaint in writing, usually by mail, to the employer and provide the employer 15 days to respond. The employer will respond in writing with what we call a position statement, meaning this is what happened from the employer's point of view. Here's documentation that is relevant to resolving the complaint, to defending the complaint, and that is sent in to the Division of Human Rights. The Division of Human Rights will forward automatically whatever the employer has sent to the complainant, ask the complainant to respond in writing, and then, in almost all cases, the Division of Human Rights will hold what's called an investigative conference, where the investigator will ask for the complainant to attend, the employer and its representatives, its witnesses to attend, and the investigator will conduct kind of a verbal investigation based on what the investigator has already received in these various written submissions. Now, the Division of Human Rights is a process where parties can, but need not necessarily be represented by counsel. Very often complainants are not represented by counsel. Employers, again, have the right to be represented by counsel. We would recommend that you consult with an attorney before responding, because how you respond may frankly influence the whole case, right? It's very difficult after the case has progressed to then perhaps change one's arguments, change one's approach, and wish that one had done things differently out of the box. That being as it may be, that is the usual process that the division would follow. Then the division would issue its decision, which is either probable cause or no probable cause. And if no probable cause, that is the end of the matter as far as the division is concerned. If there's a finding of probable cause, the case goes on for further adjudication, this time before an ALJ, an administrative law judge, that's what that stands for, who is employed by the division, who will conduct basically a mini trial. Formal rules of evidence apply, formal questioning applies, there's cross-examination, all of that. What we wanted to bring to folks' attention is that the division over the past few months, and maybe even, I think we started to see this sometime around last summer. In the age of COVID, the division is applying a different process for complaints that have to do with COVID. So this could be COVID-related discrimination or COVID-related harassment or a failure to accommodate one's COVID-related disability claims. In complaints that allege something related to COVID, instead of doing the normal beginning process where the division first asks for these paper submissions and does an exchange between the parties of those written submissions, instead of that, if the complaint mentions COVID, then the division is speeding up the process, reaching out immediately, usually via email, to the employer and scheduling a conciliation conference to attempt to resolve the complaint. And this is before the parties, at least the employer, has submitted anything in writing responding to the complaint. At that conciliation conference, which is usually very quickly scheduled, within a week to 10 days of the employer even getting the first notice that there's any complaint at all, at that very first conciliation conference with the investigator will start by trying to settle the case, right? What does the complainant want? What is the employer willing to do? If it does not settle, then the investigator is immediately in that same call moving forward to investigate the complaint, asking questions of the complaint about the merits of the complaint, asking questions of the employer about the merits of the complaint. And that's really the critical piece that we wanted everyone to understand, that it is a different process. It is a speedier process, and it is a process you really have to be fairly proficient in, because what you think may be and what is kind of billed as being a conciliation conference, a conference just about settlement, if it doesn't settle, will immediately go into the investigation stage. Therefore, again, all the more reason to reach out to counsel if you get notice of a division complaint, so that you can understand the process, understand your rights in the process, your arguments that you can raise in the process. We've also, we know, by the way, that the complaints that qualify, that are kind of put into the chute of the very quick attention, head of the line, moving to conciliation before anything else, is any complaint that even mentions the word COVID, even if the substance actually has nothing to do with COVID. So if there is a complaint that just mentions as a background fact, oh, and by the way, my employer closed down due to COVID in March, boom, that complaint has now gone into this expedited process. That's it, Pete. Just that kind of quick reminder to always be on our toes. Things are changing all the time.
Thanks, Laura, and thanks everyone for being with us today. We appreciate you joining us every week. We'll be back here again next Tuesday. In the interim, everyone, please stay safe, and we'll talk to you then.